Stanger. I'm the current chair of our firm's health law group. Welcome to today's webinar. Today we're going to be talking about the new rules, relatively new rules at 42 CFR Part 2 concerning substance use disorder records. These regulations were actually promulgated, the new ones were promulgated in 2024. They're currently in effect, but they're not going to be enforced until next February 16th, 2026. So hopefully you're aware of them, and we're going to talk about the things you need to do today to make sure you comply with that deadline next February. Couple of housekeeping materials. You should have received a link, or you will receive a link for the presentation slides. Also, a couple of written resources I've made available for you, including the SAMHSA fact sheet discussing the rules and the HHS commentary to the final rule that's out there. I'm going to focus on the application to healthcare providers. There are certain aspects of the rule that apply to certain types of government agencies, law enforcement, those types of things. I'm assuming most of you are not in that category, so I'm really not going to address those things. I'm going to focus on the rule as they apply to healthcare providers. As we go through the slides, I've highlighted those changes from the prior rules that you may be familiar with. I've highlighted those major changes in red just to help you see what the new rules are. If you have questions, just as in the past, we will be recording this, so we're not going to take questions during the program, but you can submit questions to me using the chat feature. You can just email me directly, and I will do my best to respond offline. With that said, let's talk about the rules. First, what are the applicable laws? There's actually a statute out there, 42 USC 290DD-2, that addresses the confidentiality of substance use disorder regulations. That was amended in 2021, 2022 by the CARES Act. The whole purpose of the CARES Act was to try to make the new rules, the 42 CFR Part 2, more in line with HIPAA, so that you didn't have these two separate rules, or at least it minimized the effect of the two separate rules. So these new rules that were promulgated in 2024 were meant to implement those portions of the CARES Act that changed the 42 CFR Part 2. Remember, though, that even though we're talking about Part 2, there are also the HIPAA rules that are still out there and still apply to this information. There's also other rules that may apply, including the information blocking rule, which governs access to information, and there may be other federal or state laws or regulations, so you need to make sure that you consider all those relevant laws and rules when you're talking about substance use disorder records. In generally, you need to make sure that you comply with the most restrictive law. In most cases, 42 CFR Part 2 is going to be more strict than HIPAA, so if there's a conflict between the two, make sure that you comply with Part 2. But as I mentioned, part of the purpose of those new regulations was to more closely align the 42 CFR Part 2 rules, the SUD rules, with HIPAA. Unfortunately, they didn't do that great of a job. There are some helpful things in there, but unfortunately, you still have two sets of regulations that you've got to comply with. These new rules are in effect now, but they're not going to be enforced until February 16th, 2026. So let's talk about what the rules require. Stepping back, the government way back when was concerned that people would not get substance use disorder treatment because they were fearful of the ramifications, that if that got out, it might adversely affect employment, could affect, law enforcement after them or the like. And therefore, years ago, the Congress passed the statute that provided special protection for substance use disorder treatment, so that it would encourage people to get that care, because so they weren't just afraid that that information was going to be out there. In general, the Part 2 programs and certain recipients of substance use disorder programs or SUD records may not use or disclose that information that would identify a person as having had or having been referred for SUD, even if they don't have it, unless the person provides written consent or there's an exception that allows you to make the disclosure. Specifically, the new rules are very clear that you may not use or disclose SUD information in any civil, criminal, administrative, or legislative proceedings conducted by any federal, state, or local authority. When we're talking about SUD records today, even though we use the term record, it's really broader than that. It's any individually identifiable SUD information, whether it's recorded in paper or any other form. Just the information out there is also protected by 42 CFR Part 2, even if it's not quote unquote a record. What are the penalties for failing to comply with this? Well, under the old rules, there used to be a criminal fine that they would specifically impose. You could potentially also be liable for HIPAA violations, but under the new rule and the statute, they basically incorporate the HIPAA penalties. So instead of the old statutory process, now, if you violate the new statute, then the criminal penalties are those that could be imposed on anybody for HIPAA violations, anywhere from $50,000 to $250,000 fine and up to 10 years in prison. In addition, if you are a covered entity under HIPAA or covered by the 42 CFR Part 2 rules, not just programs, but other holders of SUD information, then the civil penalties could be anywhere from $141 up to $71,000 per violation if you do not act with willful neglect. If you act with willful neglect, then it could be a mandatory penalty of $14,000 up to about $2 million per violation, and each record that is improperly disclosed could be a separate violation. So you need to make sure that you're taking these issues very seriously. Last month, HHS Secretary Kennedy delegated enforcement to OCR. That's no surprise because under the CARES Act, they specifically stated that the HIPAA enforcement process would apply to Part 2 violations. That means that if somebody violates Part 2, they can complain to the OCR. The OCR can step in, do their investigation. They can require settlement agreements. They can impose civil penalties. Not only that, but you also, just like in HIPAA, you've got to affirmatively narc on yourself if you violate the 42 CFR Part rules, just like under HIPAA. So under HIPAA, you've got the breach reporting rule. Under Part 2, you've got a similar breach reporting rule. All right, let's talk about the applicabilities. I mentioned the rules of 42 CFR Part 2 apply to substance use disorder records in any form. SUD records are those, the information, it generally prohibits the use or disclosure of the information, whether it's recorded or not, without the patient consent if the information identifies a patient as having had, or referred for a substance use disorder. And it's created, received, or acquired by our federally assisted SUD program. Now, SUD means a cluster of cognitive, behavioral, and psychological symptoms indicating that the patient continues using the substance despite significant substance-related problems such as impaired control, social impairment, risky use, and pharmacological tolerance and withdrawal. The key there is whether or not those records were created through a federally assisted substance use disorder program. Well, there's two portions of that. You have to be federally assisted and you have to be a program. When it comes to federally assisted, it's pretty much if you're involved in any way with the government or getting payment from the government, then you're going to be federally assisted. Federally assisted means that you're carrying out your practices or services under a license or authorization granted by the U.S. Department or an agency, including you're participating in Medicare, you've got a DEA registration or other authorization to conduct maintenance, treatment, or withdrawal management. If you are supported by funds provided by a U.S. Department or agency, that also makes you federally assisted. So if you're participated in Medicare, Medicaid, or other federal government programs, if you're tax exempt or claim tax deductions relating to your program, well, then they're also federally assisted. Or if it's your services are conducted directly or by contract or otherwise by any department or agency of the United States, then you are going to be federally assisted. So almost all of you are probably going to be federally assisted. If you are purely private pay and are not, licensed or created, by the government in any way, not involved in any federal funds, then you may not be subject to 42 CFR Part 2, but that's probably not very many of you. Even then, of course, you still have to comply with HIPAA if you're a covered entity under HIPAA. So in most cases, the question is not whether or not you're federally assisted, it's whether or not you are a program. Well, what is a program under 42 CFR Part 2? Well, it depends on whether or not you are in a general medical facility or practicing apart from a general medical facility. A general medical facility generally means a hospital, trauma center, FQHC, maybe primary care practices. It's kind of these general facilities that provide care. So the rules are this. If you're not in a general medical facility, you're an individual or any, but you're not in a general medical facility, then you could be considered a program if you hold yourself out as providing SUD diagnosis, treatment, or referral for treatment, and you actually do provide SUD diagnosis, treatment, or referral for treatment. That's if you're operating separate apart from a general medical facility. If you are affiliated with or in a general medical facility, then the question is, it applies whether or not if you are identified unit or to certain medical personnel or staff. If your medical facility has an identified unit that provides this stuff, the question is, does that identified unit hold itself out as providing SUD diagnosis, treatment, or referral for treatment? And it actually does provide SUD diagnosis, treatment, or referral. On the other hand, if you don't have an identified unit in your general medical facility, but you have medical personnel or staff, then the question is the primary function of those medical personnel or staff, is it to provide diagnosis, treatment, or referral for treatment? And if you're identified as such providers, so your facility, advertises or otherwise indicates that you're identified as a provider who provides that, then you could be a program for purposes of 42 CFR Part 2. Now, some of that depends on whether or not you're holding yourself out as an SUD provider. What does that mean? Well, hold yourself out means that you engage in an activity that would lead one to reasonably conclude that the individual or entity provides SUD diagnosis, treatment, or referral for treatment. For example, through advertising or marketing. SAMHSA issued some FAQs a while ago that were somewhat helpful. They state that holding yourself out may include state licensing procedures. So if you go through and get licensed to provide SUD care, if you advertise or post notices that you do this, if you have certifications in addiction medicine and you're making that available or publishing that, if you're listing yourself in registries, internet statements, consultation activities for non-program practitioners. So for example, you go out and advertise or meet with other entities to say, hey, we provide these types of services. Or if you provide information presented to patients or families that said, hey, you can come here and get this SUD treatment, then you're probably holding yourself out as and may in fact be a federally assisted program and covered by Part 2. Now, a Part 2 program is not simply because you may provide some SUD care in the course of providing other types of services. For example, emergency room personnel, they may regularly, on a regular basis, treat persons for overdosing, but that doesn't necessarily make them an SUD program unless their primary function is to diagnose, treat, or refer for SUD care, or the emergency room itself holds itself out to the community as a provider of such SUD services. So if it's just kind of part of what it does, but it's not really holding itself out as providing that service, then it's probably going to be okay. But on the other hand, if it's advertising, marketing, that it does that, then it could be holding itself out as and become a Part 2 program. Similarly, a Part 2 program is not providers who prescribe controlled substances to treat an SUD, but who do not otherwise hold themselves out as providing SUD treatment. The gist of this is, look at if you're out there advertising yourself, holding yourself out to the public as providing this types of care, and you're actually doing that, then you're probably going to be a program and you're going to have to comply with Part 2. Now, if you're in a general medical facility, the Part 2 program is just that unit or those individuals who constitute the Part 2 program. The rest of the facility, the information, and the rest of it outside that program is not the Part 2 facility. That means that the part that is the program has to apply the Part 2 rules to its program, not necessarily the rest of the Part 2 facility. Now, Part 2 applies to federally assisted substance use disorder programs under those standards we just talked about, but it also extends to recipients of SUD records. So those confidentiality requirements that we're going to talk about generally apply to certain recipients, including entities with direct administrative control over the Part 2 program, a qualified service organization, we'll talk about that in a minute, lawful holders, we'll talk about that in a minute, third-party payers to whom records are disclosed by Part 2 programs or per the patient's written consent. If they're a third-party payer, the claims go to them, then they've got to comply with Part 2. Or any person receiving SUD information in any civil, criminal, administrative, or legal proceeding, if they got that information appropriately or received that information, and they're going to be sucked into Part 2 and they've got to comply with the Part 2 confidentiality requirements. Okay. One of those requirements is the qualified service organization. Qualified service organizations have to maintain the confidentiality of Part 2 information and comply with Part 2. What is a qualified service organization, or a QSO? It's essentially like the business associate for purposes of HIPAA. A QSO is an entity that provides services for a Part 2 program. Could be data processing, collections, dosage prep, lab analysis, legal services, consulting, whatever. And that QSO has a written agreement with the Part 2 program by which it agrees to comply with Part 2 in dealing with the SUD information for the program. Among other things, that agreement, or Qualified Service Organization Agreement, QSOA, that has to require that QSO that by contract, they're going to agree that if they get subpoenaed or otherwise for Part 2 records, they have an affirmative obligation to resist judicial proceedings to obtain the SUD information unless that disclosure is otherwise allowed by the regulations. It includes business associates of a Part 2 program if the Part 2 program is a covered entity under HIPAA. But just think of the QSO as a business associate if you were thinking about it in HIPAA terms, and that QSOA is essentially your business associate agreement. Part 2 also extends to lawful holders of SUD records that are received from a Part 2 program. It's those entities that receive those Part 2 records because they have received the SUD information as a result of one of the following. So to become a lawful holder and be subject to Part 2, you must have received that Part 2 information per the patient's written consent, plus you received a notice along with that consent notifying you that, hey, this stuff is protected by Part 2 and you got to comply with it. Or alternatively, if you are the recipient of that information under one of the exceptions that you can receive the information without written consent, like a QSOA or QSO or those types of situations. In those situations, you are a lawful holder. That means that you must comply with Part 2 whether you wanted to or not. Under the new rules, lawful holders may redisclose SUD information that they receive under very limited circumstances, and whether or not they can further disclose that SUD information they get depends on whether they're a Part 2 entity themselves or whether they're a covered entity or business associate under HIPAA. Well, what about other Part 2? What about other providers who may receive Part 2 information? Does that make them lawful holders? Well, if they receive that information with the patient consent and they got that notice, then they'll be a lawful holder. Even without that, a Part 2 provider, if you're a covered entity, you may disclose information to another Part 2 entity or to another entity that is not covered by Part 2 or is not a Part 2 program. If you get the patient's consent, you would also provide that notice. That means that that non-Part 2 provider who receives that information generally has to maintain the confidentiality of that information. Now, its obligations depend on how they got that information. If they got that information just simply orally, that a Part 2 program disclosed the oral information to them so there are no written records, then they've got to maintain the fact that contained in that information they disclosed orally. They've got to maintain the confidentiality of that. But if they reduce that information down to writing, that writing itself is not subject to Part 2. On the other hand, if they got written documents or written records from a Part 2 program, then those records then become Part 2, and they're going to have to maintain the confidentiality of those records consistent with Part 2. If that just goes into the general medical record, along with all the other medical records that may exist, then that all of those other medical records also have to now comply with all the Part 2 requirements. If the Part 2 provider doesn't want to do that, then they can segregate those Part 2 records that they got so that they don't have to comply with all those records. The bottom line is, if you are not a Part 2 provider and you get those Part 2 records, then you're probably going to want to segregate those records, keep them different from your rest of the medical record. Otherwise, the standards for Part 2 are going to apply to all of your medical records. All right, let's talk about the confidentiality issues. Again, the SUD rules, Part 2, generally prohibits the use or disclosure of SUD information, whether recorded or not, without the patient's consent, if that information is created, obtained, or maintained by a federally assisted substance use disorder program or a Part 2 program, and it identifies a patient as having had or been referred for an SUD. It's like HIPAA, right? It's pretty broad. It includes the patient's name, their address, social security number, photos, or any other identifiable information that would identify who the patient is or could be used to identify the person and indicate that they have had, or have been referred for SUD. If you go in there and completely de-identify that information, like under HIPAA, then Part 2 no longer covers that information, but it would have to be de-identified. Once you get that information or create that information, any use or disclosure of SUD information must be limited to that info which is necessary to carry out the purpose of the disclosure. It's common to like the HIPAA minimum necessary standard. Note that those confidentiality requirements apply even if the person seeking the information already has it or could get it someplace else. Even if the information is sought by law enforcement, you still can't disclose the information unless law enforcement jumps through certain hoops. Even if the use or disclosure for civil, criminal, or administrative process, legal proceedings, the rules specifically prohibit the use of that SUD information in those proceedings unless certain conditions have been satisfied. Even if it comes to a situation where you get a phone call asking if a patient is there, if your response would disclose that this person is there receiving SUD treatment or would otherwise disclose SUD records, then you can't respond in a way that would indicate that this person was there for SUD. So in those situations, you couldn't make those disclosures unless you had either the patient consent or you have an authorizing court order that would allow you to make that disclosure per Part 2, and that's a special kind of order. It's not just a regular subpoena. We'll talk briefly about that later. If you get those phone calls, you may acknowledge the person's presence if they're in a facility and that facility is not publicly identified as only an SUD facility, and you don't say anything that would indicate that that person is there receiving SUD. On the other hand, if your facility is an SUD facility or the patient is there in a distinct unit, that would, if you disclose that would indicate that the person is an SUD patient, then you cannot respond in a way that would reveal that information. The regulations, curiously enough, do state that you may tell the requester, you may give them a copy of the Part 2 regulations and state that they restrict disclosure of SUD information, which I suppose the only reason you would do that is if the person was there. So you're kind of telling them, but nevertheless, the regs say that if you get that kind of a request that would otherwise disclose the person's an SUD patient, then you can provide these records, but you can't otherwise state that Part 2 or these records apply to this particular, or these limitations apply to this particular patient, because that would indicate that they're an SUD patient. All right, so the rules set forth situations when you may disclose information with the patient's consent, also limited exceptions where you can disclose SUD information without the patient's consent. Let's talk about each of those. First, let's talk about disclosures with the patient's consent. Generally, the general rule is you can't use or disclose protected health or SUD records, excuse me, lapsed back into HIPAA there. You can't use or disclose the SUD information unless you have the patient's written consent. Now, that written consent has to satisfy certain requirements under the SUD rules. It's not necessarily the same as an authorization under HIPAA. In order to qualify for satisfy the consent requirements that would allow you to make the disclosure, your consent form has to have those elements that are contained up there in that particular screenshot in that slide. Now, when you're talking about SUD records, if you're talking about counseling notes get special protection. So if you're going to have counseling notes, then you can't, you would need a special consent that would allow you to disclose those counseling notes. That would have to be separate from a consent that allows you to disclose other SUD records. Think of counseling notes like psychotherapy notes under HIPAA. Remember, HIPAA gives psychotherapy notes special protections. It's not all records dealing with psychotherapy, or in this case, it's not all records dealing with SUD. It's only certain types of records. Basically, it's only those notes that are recorded in any medium by a Part 2 program provider who is an SUD or mental health professional, documenting or analyzing the statements of conversation during the SUD counseling session, and that are separated from the rest of the patient's SUD record. They are not the medical record. It's just basically the notes that that SUD counselor uses from which they then generate the rest of the medical record, and they have to be separate in order to be counseling notes. If you do get a request or you want to use or disclose counseling notes, then you have to get a special consent form from the patient that is specific to those counseling notes. As I mentioned, under the new rules, they made it very clear that you generally not use SUD information in any civil, criminal, administrative, or legislative investigation or proceeding. So if you have the police showing up and want this information, even if they've got a warrant or they've got a subpoena, you can't disclose that without the patient's written consent, or you get an order from the court specifically authorizing the disclosure of Part 2 information. That order from the court has to include a subpoena and a separate order from the court. It's not just a court order that's general. That doesn't work. There's a special process that they have to go through in order to get that. We're not going to cover that in this presentation today, but just realize that if you get the police or law enforcement up there, they have to provide a special order accompanied by a subpoena that addresses the Part 2 information. If you can't rely on a defective consent, so you can't use or disclose information if the consent's defective, which means that the consent has expired. On its face, it doesn't have the elements that are required for an effective consent. If you know that the patient has revoked that consent, or if you know or through reasonable diligence could have known by that the person holding the records, if you know that some representation in that consent form is a material false, then you can't rely on it. So it's similar to the HIPAA authorization rules. So the general rule there is you've got to have the patient's consent to use or disclose the to disclose the SUD records. Now, if you do get the patient's consent to make that disclosure, when you disclose that information to the third party per that consent, you've got to provide to that third party a copy of the patient's consent, the written consent, and you've got to accompany that consent with one of two required statements. So if you're going to make that disclosure, you've got to give whoever's receiving that a copy of the consent or provide a clear explanation of the scope of the consent, and you've got to provide one of the two required statements. Those statements are basically to put that person on notice that, hey, you are now going to be a lawful holder, and therefore you've got to comply with Part 2 with regard to these records. There's two alternative forms that you can use, either one. There's the long form, and quite frankly, if I were a Part 2 program, I would use the long form because it's the one that really explains to the recipient their obligations to maintain the confidentiality of that information. The long form contains the regulations contain the specific language that you've got to use. It's up here on this slide. Alternatively, you could just use a statement that says 42 CFR Part 2 prohibits the unauthorized use or disclosure of these records. You could just use that if you want to. Okay. Under the new rules, probably the most significant part of the new rules for most of you who are Part 2 programs, it now allows the patient to give a single written consent for all future uses and disclosures for purposes of treatment, payment, or healthcare operations. So rather than having to get a separate consent for each time you want to disclose information for purposes of treatment, payment, or healthcare operations, all you have to do is when that patient first shows up or while they're there, they can give you a consent that applies to all future uses or disclosures of that for treatment, payment, or healthcare operations. And as long as you rely on that, and as long as the patient doesn't revoke that, then you can go ahead and disclose those records for treatment, payment, or healthcare operations without having to go back to the patient and get a separate authorization or consent each time. So if you're a Part 2 program, you're going to want to make sure that you now start getting these consents from the patient when they show up that would allow these disclosures for future disclosures for purposes of treatment, payment, or healthcare operations. If the patient gives a specific written consent, so that's if you're going to make disclosures for TPO, you just need one, as long as the patient hasn't done it, as long as they've authorized it for treatment, payment, or healthcare operations. On the other hand, if the patient just gives you a specific consent for a particular use, then the Part 2 program has to limit its use to the scope of that consent. Well, what about those entities who do get that information with that written consent? So you're not the Part 2 program, but the Part 2 program is disclosing this information to you as a recipient of this Part 2 information. What can you do with that information? Can you further use it or disclose it? Well, you're subject to Part 2 if you're a lawful holder, so you got to comply with the rules, and these are the rules. So if that disclosure is to you, you got the written consent, then you as the recipient can further disclose such records under very limited circumstances. If it was disclosed for purposes of treatment payment or operations, and you are a covered entity or business associate, then you may continue to use or disclose that information. You may that recipient may further disclose the records in accordance with HIPAA. So as long as you're a covered entity or business associate, then you can go ahead and further use it or disclose it just like you would under HIPAA. There is that exception except for criminal, civil, or administrative or legislative proceedings, and still you got a special bar for those things. On the other hand, if you're not a covered entity or a business associate, if you receive that information for future treatment payment or healthcare operations, then the recipient may further disclose those records consistent with the consent, but you have to look at the consent. In that situation, Part 2 applies, and you just have to comply with Part 2. If you you received that information for purposes of payment or healthcare operations, and that's disclosed to a lawful holder who is not a covered entity or business associate, so you had the patient consent, the Part 2 program got the patient consent, sent that information along with the consent and that notice, so the recipient now has that, but that recipient is not a covered entity or business associate, then that recipient may further disclose those records as necessary for its contractors, subcontractors, or legal representatives to carry out their payment or healthcare operations, but only to the extent specified in the consent on behalf of such lawful holders, and only if certain conditions are satisfied. And generally, you have to have a written contract that prohibits those recipients to further use or disclose that information in violation of Part 2. So just remember that Part 2 trickles down. It starts with the Part 2 entity, the federally assisted SUD program. But if you have those records and you're a recipient of that, even if you're not a Part 2 program, you still got to comply with that, and it limits your ability to further use or disclose that information depending upon the scope of the consent or whether or not you're a covered entity under HIPAA. HIPAA does, or excuse me, Part 2 will allow, well, let me back up. Let's say your state has a specific prescription drug monitoring program, like a lot of them do. It generally requires you to disclose certain information. Well, what if that requires you to disclose information that constitutes SUD records? Well, Part 2 applies. And Part 2 says that you can only make that disclosure to the prescription drug monitoring program if the disclosure is required by state law and the Part 2 program or lawful holder obtains the patient's written consent prior to reporting the information. So you can only make those disclosures if you get the patient's written authorizations. You're going to want to get the written consent before, when the patient comes in, that would allow you to make those types of disclosures. If you don't get the patient's authorization, then even though the disclosure is otherwise required by state law, Part 2 prohibits you from making that disclosure as part of the PDMP. There are other rules that will allow you to make certain disclosures to prevent multiple enrollments. In the interest of time, I'm not going to go through those, but just realize that there are specific rules that if you want to make a disclosure to prevent multiple enrollments in different programs, then you have to jump through those additional hoops. When it comes to disclosures with written consent to the criminal justice system, so this is a situation where the Part 2 program, the criminal justice system comes to you, says, hey, it's a condition for this guy's parole, or as part of his penalty, he has to participate in the program. You can make disclosures to that criminal justice situation if you've got the patient has signed their written consent and the disclosure is limited to those with a need to know. There are some additional specific requirements in the regs that you would want to check, but just realize that even though this person's, unlike HIPAA, even though this entity's providing those services pursuant to this direction by the court, you still have to have the patient's written signed consent to make those disclosures. All right, those are the situations. The general rule is you got to have the patient's consent. Those rules we talked about, discuss the scope of that consent, what's required for the consent, and redisclosures pursuant to that consent. Let's talk about situations where Part 2 would allow you to make disclosures without the patient's consent. Part 2 will allow you to make those disclosures without the patient's consent if they are communications within the Part 2 program. It's based on a need-to-know basis. If they're communications between the Part 2 program and the entity which has direct administrative control over the Part 2 program, then you don't need the patient's consent for that. Communications with a QSO, you don't need the patient's consent, but you would have to have a QSOA, the business associate agreement with that QSO. It would also allow you to make reports to law enforcement of a crime or a threat on the program premises or against program personnel. So it's very limited in what you can disclose to the circumstances when you can disclose to law enforcement. You have to limit the information that you disclose to the circumstances that are relevant to that particular incident, such as patient name, address, patient status, and whereabouts. Similarly, the law allows you to make disclosures to report child abuse or neglect per state law to the extent that you're required by state law, but you may not disclose the SUD records. So you can go ahead and disclose information necessary to report child abuse or neglect, but you cannot disclose those SUD records unless the law enforcement jumps through the hoops to get that special court order that will allow the disclosures. Part 2 would also allow you to make disclosures without the patient consent in the case of a bona fide medical emergency if certain conditions are met. Generally, you would need the patient's prior written consent. If you can't have that prior written consent, if it cannot be obtained, then and it's a medical emergency and or the Part 2 program is closed and unable to provide the services or obtain the prior written consent during a temporary state of emergency, then in those situations, if it's a bona fide medical emergency, you can go ahead and make those disclosures. There's also an exception that allows you to report to the FDA if the health of the individual is threatened by an error or malfunction in labeling or sell or product. You may immediately, in those cases though, where those disclosures for medical emergencies, you've got to immediately document that you made that disclosure. You've got to document in the medical record, including the name of the medical personnel to whom the disclosures were made, their affiliation with the facility, the person making the disclosure, the date and time of the disclosure, and the nature of the emergency. There are also exceptions under Part 2 that would allow you to make disclosures as part of an audit of a Part 2 program or a lawful holder on behalf of a government agency. So if you have Medicaid or some other entity or a third-party payer that wants to come in there and audit your records, then you can go ahead and make disclosures, but the rules for the disclosure differ depending on whether the records are going to be just reviewed at your facility or whether they're going to be copied or removed from the Part 2 program. Basically, you'll want to make sure that when you have the patient sign that initial consent for disclosures for TPO, that it would include those types of audits and the like. So there's additional specific requirements in the regs. Before you respond to that audit, just make sure that you look at those requirements to make sure that those have been satisfied. Once again, you cannot use or disclose SUD records in any federal or state civil, criminal, or administrative proceeding unless you have either the patient's consent or a court order that's issued per the specific requirements under Part 2. In addition, the government cannot place an undercover agent or informant in a Part 2 program or use any other information obtained from them unless they satisfy certain conditions before they do that. What are the conditions for those court orders? Well, you may disclose the SUD information if you have a court order, plus that court order is accompanied by a subpoena that specifically authorizes the disclosure, and there's a finding that the disclosure is made to protect the life or serious bodily injury, to protect against an extremely serious crime committed by the patient, or the disclosures in conjunction with or connection with a proceeding in which the patient offers testimony or other evidence pertaining to the content of the confidential communications. There's a separate process that law enforcement has to jump through with the court in order to get that subpoena in order. They can only obtain that after a hearing, and that order must limit the use or disclosure of that information outside the hearing. Again, if you get that order, you're going to want to look at the regs to make sure that that order complies with the particular rules. All right, so we've talked about the consent, the prohibition for disclosures. Generally need the consent, what the requirements for the consent were. We talked about that. We talked about situations where you can make disclosures without the patient's consent. Let's talk about minors and patients who otherwise lack capacity. When it comes to part 2, generally think of this. If the minor can consent to the SUD care under state law, then the minor controls their SUD information, right? That means that the program cannot disclose the information to the parent or guardian without the minor's consent, including any disclosures to obtain payments. So if you want to get paid for the care of a minor, you're probably going to want to make sure that you get the patient's consent before you take on that patient so that you can make the disclosure for purposes of treatment, payment, or operations. And you don't have to take on that patient until you get that consent from the patient. On the other hand, if you're in a state such as Idaho, where the minor may not consent to their care under state law, then again, you may not disclose the minor's request for treatment or to the parent or guardian unless the minor gives written consent to disclose the parent, to make the disclosure to the parent or guardian, or the minor lacks the capacity to make rational decisions. So their consent would be ineffective anyway. Any consent for the disclosure to others must be given by the minor and parent or guardian. So both of them have to be involved. So you can't just necessarily rely on the guardian in those situations. You generally need the minor's consent to make those disclosures. What about if the minor shows up there and doesn't allow the disclosure? Well, you may disclose the facts relevant to a substantial threat to the minor or other person to the parent or guardian if the minor lacks capacity to make a rational decision due to the age or mental or physical condition, and the disclosure may reduce the substantial threat to a well-being of the minor or other person. What about adult patients who lack capacity? Well, if the court has determined that an adult patient lacks capacity to make their own decisions, then you would look to what the personal representative. You'd need to get consent from the personal representative. The personal representative is the person who, under applicable state law, has the authority to make healthcare decisions similar to the standard under HIPAA. On the other hand, if you don't have a court order that's determined that the patient lacks capacity, then in that situation, that program, the Part 2 program director, cannot consent to make a disclosure of the Part 2 information except that they may consent for the sole purposes of obtaining third-party payment from a third-party payer or a health plan. That's the only situation that they may go ahead and make that disclosure without the patient's consent. Generally, you would need to have a court order that identifies a personal representative. Part 2 applies to deceased persons. It doesn't end with death. You generally, you would need the consent from the personal representative under applicable state law before you could go ahead and make disclosures. All right, Part 2 gives the patient certain rights. Sometimes your facility will require the Part 2 individual to carry an identification card. That's fine. You can require that in your facility, but you can't require them to carry that identification card outside your facility because other people may see it or find it. Under Part 2, Part 2 says that you may provide a patient with a copy or access to the patient's own records, unlike HIPAA, which says that you must provide the patient access unless you fit within an exception. That's not the rule under Part 2, but you're still going to be governed by HIPAA and also the information blocking rule. So even though Part 2 says that you may provide the patient with a copy of access, if you're covered by covered by HIPAA or the information blocking rule, the general rule is you still have to provide the patient access to their information under HIPAA or the information blocking rule, unless you fit within one of the HIPAA exceptions for those. As I mentioned earlier, the new Part 2 rules will allow you to go ahead and use or disclose information for treatment, payment, or operations, so long as you get the patient's consent, and you only need the consent once, as long as the patient hasn't withdrawn it. Now, the patient has a right under Part 2 to request additional. Well, first of all, note that the patient is not required to consent to the use or disclosures for treatment, payment, or operations. They can decline to give you that consent if they want, but in that situation, you're probably not going to want to continue their care because you're going to need their consent in order to make disclosures for payment purposes and that. So you're going to want to get that consent early on in the process, when they first come in. If they refuse to give you that consent, then you may want to decline to accept them as a patient. Now, even though they give you that consent, the patient may request that the Part 2 program restrict the uses or disclosures for treatment, payment, or operations to which they have consented, but you're not required, like HIPAA, you're not required to agree to those restrictions. Now, so you can refuse. If you don't want to agree to the restrictions that the patient places on those use or disclosure for treatment, payment, or operations, then don't agree, and you're not required to agree. Now, at that point, the patient may then decide that he doesn't want to give you the consent for treatment, payment, or operations, in which case you may say, fine, then we're not going to take you on as a patient. So that's something you'll just have to work out with them. Now, there is one exception. If, like HIPAA, if the disclosure is going to be made to a health plan for services for which the patient or another third party paid in full, then in that situation, just like under HIPAA, the patient can tell you, no, I don't want you to make this disclosure for payment purposes to this healthcare entity because I paid for it myself. In that situation, they can require that you restrict the use of disclosures to the extent that it would be contrary to that direction. As under HIPAA, under Part 2, it requires covered entities to provide an accounting of disclosures. So upon request, the Part 2 program must provide the patient with an accounting of all disclosures that were made with consents under Part 2 in the prior 3 years or a shorter time period chosen by the patient. So a patient has a right to come in there and have you make those disclosures. That would include disclosures that you make for treatment, payment, or healthcare operations. In contrast to HIPAA, HIPAA currently doesn't require you to provide an accounting for those disclosures. Part 2, you do. The accounting must meet the requirements just like under HIPAA. When it comes to making the disclosures for treatment, payment, or healthcare operations, if the disclosures are made through an electronic health record, Part 2 program must provide a patient with an accounting of disclosures for TPO made during the prior 3 years. In that situation, that's part of the HITECH Act. HIPAA has not, under HIPAA, the regulations have not been implemented to require that disclosure in that situation. Under Part 2, it does require you to make those disclosures. However, under Part 2, that particular provision requiring you to make those disclosures for treatment, payment, or healthcare operations, that's told until we get the final rules for HIPAA, until that comes out. There are certain rules for disclosures to intermediaries. Intermediaries are basically, it's basically health information databases. Under those situations, if you, upon request, and if a patient comes in there and asks that health information database or an intermediary to provide an accounting, that intermediary must provide patients with a list of persons to whom the patient's records have been disclosed in the prior 3 years. And there are additional regulations specific to those requirements. Additional patient rights. A patient has a right to file complaints, and the Part 2 program must provide a process for receiving complaints. The person may file a complaint with HHS in the same manner that a person may file a HIPAA complaint, so they can go to OCR and complain about your violations. The Part 2 program may not intimidate, threaten, coerce, discriminate, or retaliate against a patient for asserting their Part 2 rights, including for the fact that they filed a complaint. And a Part 2 program may not require the patients to waive their right to file a complaint as part of a condition for treatment. When the patient shows up at your Part 2 program upon admission, the Part 2 program has to, or if the patient lacked capacity, when the patient gains capacity, the Part 2 program has to inform the patient of that federal law protects the confidentiality of their SUD information, and if you have to give a written notice of the program's duties and privacy practices as specified in the regulations. So you have to give this notice of confidentiality protections. There are plans, well, actually as part of that notice, under the Part 2, just like under HIPAA, Part 2 requires that Part 2 entities provide the patient with a notice of privacy practices. And that notice of privacy practices has to contain certain elements. It generally tracks a lot of the requirements under the HIPAA notice of privacy practices rules, but it has some additional stuff. As part of the reproductive health rule that came out from under HIPAA. That reproductive health rule requires changes to your notice of privacy practices. The portion of the reproductive health rule that governs the confidentiality of reproductive health special rules for productivity, that was essentially vacated by a court, and the Trump administration is not fighting that. So that's gone away, but the requirements for your notice of privacy practices are still on the books. So before February 16th, 2026, you're going to want to look at and revise your notice of privacy practices. If you are a Part 2 entity, you need to make sure that the notice of privacy practices includes the elements that are required by 42 CFR Part 2. If you're just a HIPAA-covered entity, you need to make sure that your notice of privacy practices includes the additional requirements or the modified requirements that are set forth in that reproductive health rule. So you're going to want, in the interest of time, I'm not going to go through all those requirements, but in my slides, I outline the requirements that if you are a Part 2 program, what must be included in your notice of privacy practices that you provide to your patients, just like under HIPAA. You've got to make that notice of privacy practices like HIPAA. You've got to make that notice available to any person or patient upon request. You've got to provide that notice of privacy practices for Part 2 no later than the first service delivery, including if you provide your first services via email, then you've got to provide it during email. In an emergency, you've got to provide it as soon as possible after the emergency concludes. If you maintain a physical delivery site, you've got to post that notice, have it so that it's available for the patients to take with them, and you've got to post it in a prominent location. You've got to do it in a way that you're not identifying the person as a patient for an SUD program. If you maintain a website, you've got to post the notice on your website. You may provide the notice to the patient by email if the patient agrees, and you need to provide a paper copy of if the patient requests it. CARES Act, not necessarily Part 2, but CARES Act also has a broad anti-discrimination statute that I'd ought to mention. Under the CARES Act, no entity shall, and that's very broad, no entity shall discriminate against a person based on SUD information regarding the admission, access to, or treatment for healthcare, hiring, firing, or terms of employment, the sale, rental, or continued rental or housing, access to federal, state, or local courts, or access to approval of or maintenance of social services and benefits provided by funded by federal, state, or local governments. So in addition to Section 1557 or the Rehab Act or other anti-discrimination statutes, you cannot discriminate against a patient based on their SUD status. All right. Part 2 also, like HIPAA, has security rule requirements. So under the Part 2, they're not as extensive or specific as they are under HIPAA, but under Part 2, it states that a Part 2 program and lawful holders must have formal policies and procedures to protect against the unauthorized use or disclosure of SUD information or threats to the security of SUD information. Now think about that just for a second. I can understand if the Part 2 program, undertakes to provide services, right? It is a Part 2 program, and so by doing that, it knows it's going to have to comply with the security rule. But under the Part 2 rules, even if you are not a Part 2 program, if you become a lawful holder because somebody sends you those records along with the consent and that notice, then now suddenly you're going to have to comply with the Part 2 security rules, which includes having these formal policies and procedures to protect that information. Those policies and procedures must address certain elements, including the transfer and removal of records, destroying records, maintaining records in a secure room, cabinets, or facilities, using and accessing workstations, rooms, cabinets, or facilities, or de-identifying records consistent with HIPAA. Now, as long as you're a HIPAA-covered entity or business associate, you're probably already complying with this stuff anyway, so probably no big deal. But what about if you are not covered entity under HIPAA or a business associate under HIPAA, so you don't otherwise have that? Well, if you're a lawful holder, you're supposed to comply with this stuff. Now, there is an exception that those standards do not apply to family, friends, or other informal caregivers who are lawful holders. So just because you're a mom or a brother or sister who's helping out, you don't necessarily take on this obligations. But if you're another healthcare provider who gets this information as a lawful holder, then you're expected to comply with these requirements. Remember that separate and apart from 42 CFR Part 2, if you're covered by HIPAA, you still have to comply with the HIPAA security rules as well as state breach notification requirements. Speaking of breach notification, Under the new Part 2 rules, they specifically adopted a breach notification requirement that pretty much parallels HIPAA. Under Part 2, the Part 2 program must notify an individual in HHS if there is a breach of unsecured SUD information. To the same extent, a covered entity must provide the notification under HIPAA. So they basically adopt the HIPAA breach notification rules and apply it to Part 2 entities. You must report that breach of unsecured protected health information in violation of Part 2 as well as HIPAA. If it compromises the security of the privacy of the information, you've got to provide that notice to the individual, notice to HHS, and for business associates, you've got to provide the notice to the covered entity. So basically, it just incorporates the HIPAA requirements. Part 2 puts in place certain specific rules concerning the disposition of records. So if you're a Part 2 program and you go out of business or you sell your practice, your Part 2 program to some other entity as part of an asset sale or something like that, the rules specifically say that if a Part 2 program discontinues operations or is taken over or acquired by another program, it must de-identify or destroy the records. So you can't just transfer those records unless the patient gives written consent to transfer the records to the new entity, or applicable law requires the records to be retained for a specific period of time that extends beyond the acquisition or discontinuation of the program. But even then, you've got to comply with specific requirements set forth in the regs concerning how those records are maintained, whether they're maintained in paper or record, and that's all set out in the Part 2 regulations. All right, that is an overview of these Part 2 rules. Let's talk about some of the specific things you should be doing before February 26th when these rules become enforceable, when the government may come after you. And by the way, there is speculation that because Secretary Kennedy did appoint the OCR to enforce that rule, that the OCR will gear up and be ready to start enforcing that rule after February 2nd or February of 2026. So what do you need to do? Well, first of all, remember that even though the rule is not enforceable until next February, HIPAA still applies, and you still got to comply with the current rules. So don't just blow this stuff off until next year if you're otherwise covered by Part 2. Remember that there are also maybe more restrictive state laws, so make sure that you consider all of those in determining your compliance. You need to determine if and when, to what extent you are a Part 2 program. If you are, then you got to comply with everything. But even if you're not, if you're a lawful holder or you receive those records covered by Part 2, then you need to make sure that you're aware of that and begin considering what your obligations are going to be and how you're going to respond if you get that information. You need to determine if and to what extent you have relationships with qualified service organizations if you're a Part 2 program, and whether you need to modify or update your QSOAs, which are essentially those business associate agreements with those entities. You should also consider, do you have relationships with intermediaries, lawful holders, or other entities that you need to make sure that you are considering so that you can address Part 2 when you're transferring information over to those other entities. You should review and, if needed, modify your processes for disclosures of SUD information within and outside your organization, including getting consents when you need to. You should identify, draft, and execute QSOAs with your QSOs or your business associates. You're probably going to need to review and modify your existing HIPAA business associate agreements to ensure that they, if you're a Part 2 program, that they satisfy these requirements. It may require you to review, negotiate, provide training or termination of current business relationships if they can't or won't comply with the Part 2 rules. You should check your termination and notice provisions in your contracts. Even if the contract doesn't allow it, you're probably going to be able to terminate it if compliance would otherwise, or continuing the contract would otherwise violate the applicable rules. You should review and, if necessary, update your security risk assessment. And by the way, just a couple of months ago, the government did update their new security risk assessment tool under HIPAA if you want to use that. You should review and update your privacy and security policies to ensure compliance with Part 2 policy requirements, including disposal of SUD information. Even if you're not a Part 2 entity, you should be considering what you do if you do get that SUD information and how you're going to comply. Usually that means simply modifying your existing HIPAA privacy and security policies, which most of you already have. You're going to want to ensure that you have effective cybersecurity policies. You're going to want to draft and implement the new patient consent forms that comply with the rules in Part 2.
ensure it contains the required elements that are outlined in my slides and in the regulation. You're going to want to make sure, among others, that it authorizes, the consent form you use authorizes the use and disclosures for purposes of treatment, payment, or operations. You should consider having existing patients sign and execute new forms. If you're not already using that general consent form that allows disclosure for TPO, you should have them sign a new form that would allow you to do that. You're going to need to review and update your notice to recipients that accompanies the disclosures and draft your new notice of privacy rights, privacy practices, both under HIPAA and Part 2. Make sure that it contains the required elements under Part 2, as well as the requirements, if you're covered entity under HIPAA, that are required for under HIPAA. You're going to need to review, draft, and implement policies concerning patient rights, including make sure the patient has a complaint, you have a complaint process, you cover the patient's right to access their information, request restrictions on the uses and disclosures for TPO. Remember, don't agree to that unless you have to under the regulations. Make sure that you provide for an accounting of disclosures, especially if you have an electronic record system. Again, that's probably going to mean you're going to need to update your existing HIPAA policies. You're going to want to train your staff concerning all of these things, including your new policies and procedures, the new use and disclosure rules, the use of consents and other forms, the distribution of that consent, along with the notice of lawful holders when you send those records, those records have to be accompanied by the consent and the notice to lawful holders, the distribution of and compliance with the patient notice, the notice to the patients of the notice of privacy practices, and common scenarios and exceptions to the use or disclosure rules. For additional resources, the OCR and SAMHSA did actually publish, it's online, a video training dealing with the new rule. You can go to that website and you can look at that guidance from OCR that came out in 2024. SAMHSA has some additional information concerning the regulations. OCR has also published information on HIPAA in Part 2, although it hasn't been updated with the new rules. And we do have additional content and webinars on our website for free that you can access. Okay, that is it. That is 42 CFR Part 2, a brief overview. Traditionally, most of you probably haven't worried too much about this because SAMHSA has not been enforcing that, but that may change effective February of 2026. So if you are a federally assisted substance use disorder program, you need to make sure you're on top of this. If you are a recipient of 42 CFR Part 2 records, SUD records from a federally assisted substance use disorder program, you need to make sure what those obligations are that come with those records to you. Thanks very much. As always, we appreciate your participation. If you have questions, you're not the only one. I have questions about a lot of how this stuff is really going to play out, but feel free to send me an email or submit a query using the chat feature, and I'll try to respond offline. Thanks much.